Hi, my name is Courtney Brennan, and I'm an associate in the Burns-White Litigation Practice Group, where I focus in the areas of employment, business, and complex and commercial litigation. I hope you enjoyed this segment from a recent webinar, and I hope that you find it helpful. Now, as the vaccine for COVID-19 becomes more widely available, there is certainly optimism in the workplace, but employers cannot sit back and relax as we're starting to see claims continue to roll in regarding an employer's failure to provide safe working conditions under OSHA, and numerous OSHA citations are starting to be implemented on employers. OSHA's most recently issued guidance outlined the most common citations employers are being cited for, and they all have to do with a lack of follow through on the coronavirus precautionary methods, whether that's having enough PPE or being trained on how to properly use that PPE in the workplace. But we're also seeing a large increase in whistleblower allegations surging during COVID-19. In the last year, the whistleblower allegations have gone up by over 30%. As a preliminary matter, there's two different varieties of whistleblower claims under OSHA. And the first resembles the EEOC type of retaliation charges that many employers and employment lawyers are very familiar with, that require, a claimant to show that they participated in some type of activity protected by OSHA, that the employer subjected that claimant to an adverse employment action, and that a causal connection exists between the protected activity and that adverse action. Now, we know that protected activities include an employee who might file a safety complaint under OSHA or be cooperating in an OSHA investigation. Frequently cited adverse actions include, obviously, termination, some type of suspension, and whether or not that employee has been subjected to some type of maybe unfavorable job review or some type of change in their schedule. So it's a wide variety of adverse employment actions that courts consider. But the second type of whistleblower claim is more uniquely related to workplace safety, and that can occur when an employee simply refuses to work because he or she may reasonably believe that going to work presents a real danger, and specifically a real danger of serious injury or even death. Employees alleging this type of whistleblower complaint face a higher burden, as they have to not only prove that there is a reasonable apprehension of serious injury or death, but they refuse to work in good faith, and they had no reasonable alternative besides refusing to go to work, and that there was insufficient time to eliminate this condition through contacting OSHA, and where possible, that they sought from their employer a type of accommodation and were unable to obtain a correction in whatever the dangerous condition was. Under normal circumstances, if OSHA determines that the complaint has merit and a voluntary settlement cannot be reached, then the Office of the Solicitor of Labor can choose to litigate this case on the whistleblower's behalf in federal district court. And if OSHA determines that the complaint lacks merit, then obviously OSHA will just dismiss that complaint. But a very recent decision here in Pennsylvania is providing good news for employers involved. On March 30th, the U.S. District Court in the Middle District dismissed a complaint by a group of meatpacking plant workers that was filed last summer that gained some attention against the former Secretary of Labor and OSHA. The complaint sought to force the Secretary of Labor to essentially take action to address allegedly imminently dangerous working conditions on behalf of the plant's employees. They were concerned that their employer was not taking the proper COVID precautions, and they alleged filing numerous complaints with OSHA that they were being unfairly exposed to COVID-19, that there was not only a lack of social distancing on their production lines, but there was inadequate breaks for hand washing, that they lacked the proper PPE. In this case, the United States District Judge granted OSHA's motion to dismiss, as they found that OSHA properly investigated this case. And in their investigation, OSHA found no imminent danger existed at this plant. So this kind of provides an interesting scenario, as it's not too often that we see a case against OSHA in this dramatic of a manner. But, here the employees had a fear of, the working conditions they were in. OSHA found differently, and the district judge found with OSHA. But it's something to consider moving forward. Just in March, OSHA announced a 12-month national emphasis program, specifically targeting and prioritizing COVID-19 related inspections to take place over the next several months. So it's certainly something for employers to keep in mind. And given the increased resources OSHA is going to use under this NEP program, along with OSHA's general requirement that employers are obligated to maintain workplaces that are free from recognized hazards, employers need to continue enforcing existing COVID-19 safety precautions and, if necessary, implement further precautions. The pandemic is not over, and OSHA is certainly making a push to conduct additional inspections over the next several months. So this is certainly something to have on your radar. In another district court in Pennsylvania, a group of plaintiffs were allowed to proceed, alleging that they were wrongfully terminated for complaining that their employer violated state and local COVID-19 orders. So in the Eastern District of Pennsylvania, 3 plaintiffs who were all nurses alleged in their lawsuit that they were terminated after complaining about their employer, who was violating, as they allege, violating Pennsylvania's clear mandates of public policy. And so they're bringing their claims through Pennsylvania common law. Under Pennsylvania law, a plaintiff can bring a common law wrongful discharge claim where the termination of an at-will employee would threaten the clear mandates of public policy. Now, these types of claims differ from state to state, and the public policy extends beyond legislative enactments and includes policies that are so obvious for or against the public health, safety, and morals or welfare that there's virtually unanimity of opinion in regard to it. So courts are typically reluctant to extend this tort. And in this case, the court concluded that the serious public health concern posed by COVID-19, combined with the potential violations of medical and ethical rules concerning denying care to patients, is sufficient for their wrongful discharge claims to go on. While this opinion suggests that employees who complain to employers about their employer's violation of state or local COVID-19 orders may be afforded employment protections, it certainly leaves a lot of uncertainty. For one, the court seemingly combined complaints about violations of COVID-19 orders with unrelated public policy concerns to conclude that the plaintiff's allegations were sufficient to allege a public policy that was violated by their terminations. Moreover, this opinion focused on violations of the COVID-19 orders and not potentially inadequate safety precautions that didn't violate the order. But given all of the uncertainty, these cases are beginning to be filed, and employers should take care to continue following COVID-19 orders related to workplace policies specifically, and continue to implement the appropriate policies to keep their employees safe, as the rise of these types of whistleblower claims are not going away. Pennsylvania has seen one of the highest rates of complaints filed over the last year. So it's certainly something for us to keep our eye on as we continue to navigate this pandemic.